Good morning, everybody. Welcome to the CG campus for this presentation. My name's Una Fitzgerald. I'm the director of the International Law Research Program, and it's my pleasure to be your master of ceremonies today. We have many wonderful guests here today from across Canada and from the local region. And I think it's a wonderful opportunity to have a dialogue about these important issues about innovation and international trade. So just a few words about CG. CG, if you have not been to CG before, stands for the Center for International Governance Innovation, and we are a think tank, nonpartisan, focusing on issues of global economy, global security and politics, and most recently, law, rule of law in the international context. And this particular presentation fits into that topic, but obviously touches on all the others, so has a wide range of facets to it. So the topic today is TPP, the Trans-Pacific Partnership, copyright and innovation. And the question is, are Canadian creators or the public interest at risk? I would like to, I'll just give you a rundown on how the day, this session will go. First of all, there's going to be a presentation, a lecture from Michael Geist, Professor Michael Geist. Then we will have a panel with 3 participants, Barry Suckman, Myra Torfik, and Warren Clark. Then Michael will have an opportunity to respond quickly. And then we will open up for questions from the floor. And finally, there'll be some closing remarks from the Honorable David Lametti, and then I will close off. And we'll try to do this in a fairly tight time frame, keep things moving. And those of you who didn't get food yet, there will still be food afterwards. We'll cover it up, and you can have it after if that's better for you. Now, about the questions, you've all seen that there's a piece of paper on your chair. We would invite you to write down your questions and then put your hand up. I'll introduce you to 3 people who can help with gathering those questions. They are Aman, Marsha, and Lisa. Could you stand up? 1, Lisa, Masha, and Aman. Okay, so just put your hand up when you've got a question. They'll gather it, and then they'll bring them up, and that will help us get through more questions more efficiently. Okay, so without more, let me introduce our guest speaker, and that is Michael Geist, Professor of Law at the University of Ottawa. He holds the Canada Research Chair in Internet and E-commerce law. He is the editor of several copyright books and serves on many boards, including the Canary Board of Directors, the Canadian Legal Information Institute Board of Directors, the Canadian Internet Registration Authority, and the Electronic Frontier Foundation Advisory Board. In 2010, Managing Intellectual Property named Michael one of the 50 most influential people on intellectual property in the world. He's a syndicated columnist on technology law issues, with his regular column appearing in the Hill Times, the Tyee, and the Toronto Star, where he recently commented on Prime Minister Justin Trudeau's technology policy priorities. So Michael will be making his presentation now, so please join me in welcoming him.
Thank you. Great, well, thanks very much. So if we get the presentation up on the screen, that'd be good. Perfect. Thanks so much, Una, for the invitation, and thanks to all of you for coming. There are a lot of familiar faces in the audience, people that I know have been actively engaged on copyright and IP for a long time, and I'm grateful that you're here and we can continue the discussion around TPP. I wanted to particularly acknowledge and give thanks to 2 people, though. First, Jim Balsillie, who in the last week or 2 has succeeded in doing something that many of us have not been able to do, which is to elevate these issues in a really meaningful way so that there's a genuine and really robust debate on some of these IP issues, which I think is fantastic. I'd also like to acknowledge and congratulate David Lametti on his election as a member of Parliament. There's something about when one of your own succeeds in that way that fills you with, I think, an enormous amount of pride and excitement. And David has been one of the truly exceptional scholars on intellectual property for many, many years. And so to see one of our own now elected as a member of parliament is truly awesome. So congratulations, David. So you'll see the title of my talk is not exactly as advertised. I've instead called it Canada and the TPP, a digital policy failure. The reason for that is that as we were discussing what I would talk about at the time, the only TPP that we had available was a leaked version of the intellectual property chapter that had been made available through WikiLeaks a couple of days after the negotiations in Atlanta had concluded, alongside some government descriptions of the agreement that, if you take a look, I think aren't as robust as they might otherwise be. As many of you will know, over the last week or so, the full text has now been released, and so there's an opportunity, I think, to comment and engage not just, obviously, on a leaked text, but now on an official text that has been made available, as well as many of the other chapters that are there. Now, fear not, I only have 40 minutes, I'm told, and the TPP is a little over 6,000 pages. I am told there are more than 2 million words in the TPP. I haven't read them all. I'd be surprised if there were many people that had. So we're talking about an agreement that isn't your typical trade agreement. We're talking about a trade agreement that covers truly the waterfront of issues, one that will have a profound impact on our economy, indeed on our society, in just about every meaningful and measurable way. I want to focus specifically, unsurprisingly, on some of the digital-related issues, though, what we in Canada have taken to call, or at least the last government had taken to call, Digital Canada 150. It's also something that you wouldn't necessarily expect to see within a trade agreement, but when you look at the TPP, you do find provisions that deal with IP around copyright and patents. You see privacy-related provisions in the agreement. There is stuff on telecom. There's a full e-commerce chapter that includes some of these provisions. In fact, and we'll have a chance to talk about it in a few moments, there is even internet governance-related provisions. I think a rather unprecedented step, both for our government and for many other governments, to move into the space of making commitments, regulating aspects of internet governance that previously, certainly in Canada, had remained outside the purview or the direct regulatory purview of the government itself. Now, this slogan, one that you find when you walk into Indigo about Canada, the world needs more Canada, I think applies in my critique to the TPP. I think the TPP needs or needed more Canada. The basic case that I'm going to try to make here is that much of the TPP does not reflect either our existing laws or minimally even an effort to try to take some of the kinds of policies that we have developed in Canada over the better part of a decade or more and seen ways to ensure that the world gets more of that. A beneficiary, I think, of benefit both to our businesses who increasingly need to ensure that they can comply with local regulations and knowing that those same rules and regulations would be applicable on a broad basis throughout the other TPP countries, but also because I think in many instances we got some of these policies right. Instead, what we get with the TPP, and you don't have to take my characterization for it, you can take the US characterization, this isn't a made in America agreement. Indeed, this particular image comes from the US government itself. It's what the USTR, the US Trade Representative Office, is using to promote the TPP. They're not bashful about taking the position that the Trans-Pacific Partnership is fundamentally about taking US rules and finding ways to export them in effect to the other TPP countries, including our own. I think that's problematic, and I want to try to make the case for why I think that's problematic in a number of ways. If I had to characterize the Canadian strategy, the negotiating strategy, when it came to the TPP, and of course was not a negotiator, but one can see it come through manifestly, I think, within the text. It is, to borrow a phrase from football, and sometimes I suppose from hockey as well, a prevent defense approach. One in which the primary goal, it would often seem around many of these digital issues, is to ensure that as much as possible existing Canadian law will remain in place, knowing that it will be chipped away in spots here and there, sometimes more than just chipped, but really trying to prevent wholesale change from existing rules, doing very little from an offensive perspective to come in with actual demands or expectations or hopes from a Canadian perspective to see some of those policies better reflected in the agreement. For those that are fans of football, you know that the criticism of prevent defense is that it prevents you ultimately from winning. And I think that is the case here in the TPP, with an agreement that in many ways prevents us from a long-term perspective in achieving what I think would be important policy goals when it comes to digital policy. Now, I want to outline this in three particular ways, and I want to start, though, first by at least making reference to the transparency issue with the TPP. And I readily acknowledge that there is a temptation at this point in time just to, in a sense, let bygones be bygones and say, hey, yes, we had a secretive trade negotiation for many years. I think it would be useful to acknowledge that this is not typical for some of the kinds of issues that were discussed. Trade agreements may at times be negotiated in secret, but intellectual property rules, for example, are typically far more open and transparent within the context of the World Intellectual Property Organization. Privacy rules, far more open and transparent in the context of work that is done through data and privacy commissioners around the world. But nevertheless, we can say, well, it's out now. What is there to complain about? But I do think that we have to recognize that the approach that was taken with respect to the TPP, a highly secretive agreement made available only through the occasional leak through organizations such as WikiLeaks, does ultimately have a significant effect on the outcome, on the kinds of provisions that we ultimately have in this agreement. Now, for example, prior government did conduct one consultation on the TPP at the time when it was considering entering into the agreement. They never produced a report on that, but I launched an access to information request, got what the government got back, and I can tell you that the top issue that they heard about was copyright term extension. Now, you can debate whether or not that's the most important issue in the TPP or not. I think many people would say it is not, although it is a big issue from a copyright perspective. It is the issue that people chose to speak out about. Now, in 2013, I appeared before the House of Commons Committee, the Standing Committee on International Trade, to talk about the TPP, and I referenced both leaked documents that told us where things were going, including the likelihood of an extension in the term of copyright, and the fact that the public had spoken out on this issue and expressing concern that there hadn't been an effort to try to incorporate that. The response I got from the MPs, particularly on the government side, I was told by one that governments won't comment on leaks, just like they won't talk to terrorists. Now, I didn't think he was describing me in that light, but the notion here was, well, we're not going to comment on anything that you see in this agreement leading up to this point. One of this person's colleagues, and you can look at the Hansard transcript on this, said, listen, this is an agreement that is in flux. We can't really talk about any of these issues now. Come back and see us when the agreement is done. Well, the agreement is now done, and if you take the White House at its word, just yesterday, they made it clear that there is no opening for renegotiation or reconsideration. It is now a take it or leave it agreement. And so that idea that throughout the process it was a closed environment, comment later, and yet when you come now to comment later, the response, at least from some governments, is that there is no opportunity to effectively comment beyond the theater of raising comments. Now, one would hope that in the context of a new government, one that did not participate or did not lead on these negotiations, there is the prospect of revisiting some of these provisions. And I think there is a need to do that. We have experience in Canada on the benefits of conducting these kinds of policy processes in an open fashion. Some of you may well recall, there's TPP secrecy, some of you may recall back in 2007, the government had led up to introducing new copyright reform done largely in secret. The public spoke out. I was one of the people that spoke out on this. The government ultimately pulled back on that legislation, later introduced it, but most importantly, ultimately recognized that what had been missing from the process was true consultation, and held the first truly nationwide copyright consultation that we had had in Canada in many, many years. And the result was an agreement that, even if you didn't like everything, and I didn't like everything, was far more balanced and far more effective in terms of incorporating many of those perspectives than what we previously had had. Open processes do a better job of ensuring that these perspectives are better reflected in the ultimate agreement, and that was almost entirely missing within the context of the TPP. In fact, we also have experience with what happens when the public becomes aware of some of the implications of these agreements that are conducted in secret. Witness the Anti-Counterfeiting Trade Agreement, ACTA, that we were also a participant in, also conducted in secret and ultimately defeated on the floor of the European Parliament. Those are MEPs holding up signs, "Hello Democracy, Goodbye ACTA," as they voted down an agreement that is now effectively dead, given that the Europeans have walked away from it. So there are real implications from that non-transparent process. Even more, though, mistakes happen. Now, after the leak of the Atlanta IP chapter, so the concluding chapter on intellectual property, WikiLeaks releases this text, and about a week or so later, I post a blog post talking about how the TPP creates a backdoor takedown system. My concern was this provision here, and we'll talk a bit more about the notice and notice rules in just a moment. But one of Canada's clear goals was to preserve a system that the government invested a lot of political capital in, known as notice and notice, that seeks to allow internet providers to have a safe harbor, and in return, their obligation is that if a rights holder says there's been an infringement, they will send along that notification to the provider. The provider is obligated to forward that notification along to the subscriber. The US was hoping for a takedown system similar to its own, and Canada wanted to preserve notice and notice. Now, we ultimately, the negotiators were able to get a carve-out for Canada, or at least so they thought, and I think that ultimately have been proven right that they have. But one of the conditions for that was that the government agreed, the Canadian government agreed to induce internet providers to remove or disable access to material, in other words, to take down or block material upon becoming aware of a decision of a court to the effect that the person storing the material is infringing copyright. In other words, if an ISP or a host company received a court order or a court ruling saying that this was infringing conduct, they would be induced to take that content down. The concern that I expressed in the blog post was that a court in this context could be any court, and our rules differ from other TPP partners, so that you could, for example, have an Australian court issue a ruling saying that this was infringing content, yet in a Canadian context, it might well be non-infringing, let's say covered by something like the user-generated content provision that we'd have, and yet under the TPP, we'd be required to block access to it. Well, last week, we got the TPP chapter, and lo and behold, the language has changed. And so now it says that it's now become aware of a decision of a court of that party. In other words, of a Canadian court. Now, I think that's a good thing, right? I think that's more reflective of what Canadian law is about. But if we are talking about a 6,000-page agreement with 2 million words, this surely is not the only instance where there is going to be legislative drafting issues or other unintended consequences that arise out of the text. And the problem when you conduct these agreements without the opportunity for experts and others to actively participate and review, unless you happen to be the United States, it would seem, you've got what you ultimately end up with are agreements that I think are going to be flawed, not just here, but in many other places. And we will face difficult questions about how to address those issues after the fact, after the deal's already done. So that's part of the problem, is the transparency side. But even more, of course, is the substance. Now, with one other caveat or issue that I think has to get mentioned, and that is that if we look at the TPP sort of solely on its own within the text and look at existing Canadian law, we are missing an important part of the story. And that is that the evolution of Canadian intellectual property law over the last number of years is not solely reflected by changes that the TPP might require, but also changes that we undertook over the last number of years, either in anticipation of the TPP or as part of the same trade strategy that had been employed over the last number of years. In other words, the shift and the change in Canadian law isn't just TPP within those 6,000 pages. It's the last 5 or so years that either anticipated TPP or actually have reflected or will require changes through other agreements, for example, the Canada-EU trade agreement. So as an example, within the context of the TPP, many of you may know that we were a latecomer
to the trade negotiations on the TPP. And in fact, there was opposition to having Canada join the TPP. And so it took considerable effort on the part of the government to convince largely the United States to allow us to participate in these negotiations. There was, according to numerous reports, a price to be paid for Canada to participate in that, and many are of the view that part of that included the inclusion of digital lock provisions, anti-circumvention rules within our 2012 reforms. Now, this is an issue that, again, when publicly canvassed as part of that public consultation, this issue, almost more than any other, was one that the public was strongly against. You had many innovative companies that had said they were concerned where Canada was going, and that even if we were to adopt anti-circumvention rules, the specific Canadian rules went far further than was necessary under the WIPO Internet treaties. And yet we included that in part because that was part of the price of admission. Our laws on that area are at least in part attributable to part of that trade strategy. Many of the patent changes that you see in the TPP, it's true, aren't necessarily new, but they're not new in part because we just agreed to them within the last 24 months as part of the Canada-EU trade agreement. And so this doesn't all happen in isolation. It happens as part of a broader context and a broader strategy. And so the changes, I think, are more dramatic than are sometimes appreciated, in part because we were required to make some of those changes. We additionally passed, for example, recently Bill C-8, new border measures and anti-counterfeiting provisions measures. That also doesn't happen in isolation. It happens in a context where we are facing continual U.S. pressure as part of a desire to join the TPP, or through what is known as the Special 301 watch list, where Canada is painted as sort of bad guy as part of intellectual property protection and badgered until it starts making changes that better satisfy the U.S., although as we'll see in a moment, they are still not satisfied with border measures and have tried to put us in a sense on probation within the TPP. Now there are real changes that come up within the TPP on copyright, although if you read the summary that the government put out on copyright in the immediate aftermath of the agreement in Atlanta, you'd be hard-pressed to realize that that was the case. As in some instances, there was not even any references to the fact that these were some of the changes. One of the most significant is an extension in the term of copyright from the current Berne standard of life of the author plus an additional 50 years after they have died to now life plus 70, meaning that we will have decades of material that will be kept out of the public domain here in Canada. Now, I also launched an access to information request on the work that the government had done on this issue. And it appears that there was little, if any, independent study. There was environmental scans to see the studies that others may have conducted on the costs of the term extension, but little in the way of our own internal economic analysis. Perhaps there is others, but it didn't turn up through that ATIP. Contrast that with the government of New Zealand, which just released this week a lengthy economic study on the cost it anticipates it will face as part of the extension in the term of copyright, estimating it at 55 million New Zealand dollars per year on an annual basis. That's for a country much smaller, obviously, than Canada, and one might well expect that the costs that we would face just on this issue alone run into the hundreds of millions of dollars, based at least on the New Zealand terms. We passed digital lock rules, as I mentioned, in 2012. The TPP now requires new additional criminal provisions as part of some of those rules, rules that were in fact rejected when we went through that process, saying that it wasn't strictly necessary. Canada and our Supreme Court has often talked about copyright balance and the importance of getting that balance right. There is a balance provision that's found in the TPP, but it's weak. Unlike mandated requirements like term extension, balance become aspirational goals when you take a look at the TPP. So too with technological neutrality, discussed and indeed embedded now within our law by the Supreme Court of Canada, and yet a hierarchy of rights, a layering of rights, something embedded within the TPP itself. And then even with our recently passed, as I mentioned a moment ago, our recently passed anti-counterfeiting rules, the U.S. unsatisfied with how far we are going, and so it's put us on probation. There is a side letter to the TPP that mandates that somehow now Canada has to report on what it's doing every 6 months, as if we're some sort of naughty student to the teacher. Every 6 months, report back to the United States on everything that we are doing, and the U.S. has the right to demand new meetings on these issues anytime it sees fit. In other words, they're not happy. They weren't able to get changes directly in the TPP. Instead, they're using this mechanism to continue the exertion of pressure on Canada when it comes to copyright. Now, those are some of the changes, but perhaps even more, this is the prevent defense. Let's try to ensure that as little as possible gets chipped away. But even more, there is so little of what we have done in Canada that is reflected as either standards or requirements within the TPP itself. So that notice and notice rule, for example, is a good rule. It hasn't been used well over the last number of months because there are no regulations that were needed associated with it, but as a standard, it's an effective standard, one that is proven to work and is far more respectful of both the rights of the rights holders as well as the privacy rights of users themselves. And yet, rather tellingly, the condition that came with Canada being able to preserve its notice and notice system is that no other country could do so as well. At the very beginning of this exception, it states that only a party that has these rules in place at the time of agreement, that the agreement is reached, is entitled to rely on this exception. In other words, the US was willing to allow this to be included, but on the condition that no other TPP country now or in the future could actually implement it themselves. Yet there is strategic, I think, objectives for Canada to see those same kinds of policies adopted elsewhere. We don't find that happening here. We've adopted new rules on user-generated content in a non-commercial context, innovative rules that other countries are thinking about. There's nothing about it in the TPP. Just this week in Silicon Valley, several members of US Congress held a hearing on copyright reform in the United States, and many within the tech community specifically cited Canadian new caps on statutory damages, recognizing that there needed to be a difference between the damages for commercial piracy, commercial infringement, as opposed to non-commercial activity. We have that reflected in our law, and it's a positive reform, but you won't find it in the TPP. You won't find it as taking Canadian rules and putting them elsewhere. In fact, many of the other exceptions on personal use and format shifting and the like, found in Canada, not found as a requirement in the TPP. Indeed, there is an exception talking about, or a provision talking about limitations and exceptions, and it too doesn't require anything strict or mandatory, one of the weaker provisions that you'll find within the IP chapter, no strong requirements at all. And then even if we think about the way the TPP deals with international treaties in the area, it identifies a whole list of IP treaties that people have to be compliant with, but notably absent is the recently concluded Marrakesh Treaty for the visually impaired. And so digital locks or some of the other rules that you find coming out of those treaties, those are strictly required by the TPP. Ensuring access for the blind through an innovative new treaty that has been passed by a growing number of countries around the world, You won't find that in the TPP as a strict requirement as part of requiring Marrakesh. There is an expansion of some of those existing treaties, though. So the WIPO Internet treaties include provisions on digital locks. The language that you find within the TPP goes beyond what is strictly required, not just in WIPO, but in fact even goes beyond what was required within ACTA, the treaty that, as I mentioned off the top, was rejected by the European Parliament. And the Berne Convention, as I mentioned, we've extended the term of copyright despite the fact that we are consistent already with that Berne Convention standard. But it's not just, and I think it's important to recognize, this is not just ultimately about copyright now. This is about digital policy more broadly. So in a privacy context, there are privacy provisions requiring privacy rules. We have privacy rules that are widely regarded as being amongst the best in the world, seeking to bridge an EU approach with a US approach that might have worked really well as a standard within the TPP, as a standard that we would ensure that Canadian companies compliant with Canadian privacy rules might see those same rules reflected as a requirement elsewhere. And yet the TPP itself ensures that even something as little as voluntary undertakings, the US approach, as long as you have voluntary undertakings with a privacy policy that can be enforced by a regulator, that is seen as good enough. That good enough is seen as so weak that the European Court of Justice recently rejected the EU-US safe harbor, taking a look at the surveillance activities that are taking place and saying that it could not credibly provide an appropriate level of protection for personal information being transferred from the EU to the US. In fact, it targets those same issues in the TPP. So there are restrictions on the ability to create both data localization rules, rules that would require companies who take our personal information to store it within the jurisdiction where it might benefit from stronger protections, or restrictions on data transfers, transferring data from one jurisdiction to the next. Now, we've already seen a growing number of countries and jurisdictions thinking about those kinds of rules, particularly in a post-Snowden environment where concerns about where the data is housed or where it is transferred to is for many of increasing importance. And yet this treaty seeks to stop countries by and large from doing that. There is an exception for a public purpose, but then there is an exception to the exception that creates limitations around that. And as I'll talk about in just a moment, all of this with the overhanging threat of a company who is unhappy with this using the investor-state dispute resolution rules to try to hold the government accountable financially for the rules themselves. Canada has tougher anti-spam laws. Barry may care to comment on why that's a bad thing. We've debated this for a number of years now. I think that higher watermark when it comes to anti-spam, requiring a clear opt-in, allows our online marketers and other companies to gain better trust amongst consumers and advance the electronic economy. These rules, again, not reflected in the TPP. Instead, we have the weaker US standard. And then there are digital policies that pop up here as well. So there is a net neutrality provision, but it is incredibly weak. Again, we could have done better by having more Canada in the agreement. The CRTC has had its internet traffic management practice rules in place for 5 or 6 years. It has been used effectively to deal with internet providers and others who overstep in how they manage their networks. It's provided a real way for consumers and the public to complain about their network providers where they feel that their content is being blocked or that they're subject to unfair traffic shaping that may result in new innovative companies and technologies not being able to have a fair opportunity to ensure that their users are able to access those on the same terms. I've launched also a number of access requests with the CRTC and seen firsthand the complaints that the public makes on some of these issues, and sometimes they're serious, to the point that we had one instance last year where you had an ISP that was effectively blocking access to the Google Play Store, but weren't doing it for the comparable Apple Store. And I said this was all just a mistake, but this is a competitive electronic environment, and you need systems to ensure that where these issues arise, there is a mechanism to deal with them. We have that in Canada, but you don't get that within the TPP. There's a prohibition on mandating source code, so that you can't tell companies that they have to provide the source code that underlies some of their products in mass market products. We've already had people like Stuart Baker, who's been one of the leaders on cybersecurity in the United States, say that this is a major cybersecurity threat in and of itself. That today it may well be the United States that is typically shipping code elsewhere, which is why they're happy to see that kind of provision. But what happens when we get Malaysian or Vietnamese coders working with some Chinese coders or Russian coders, and they're shipping some of their products within the TPP, and we have now prohibited ourselves from mandating the disclosure of those rules? What happens when consumer agencies and others take a look at what happened with Volkswagen's emission standards and argue that one of the ways to deal with those kinds of violations is to mandate the availability of the source code that was underlying those technologies? And yet the TPP now says you cannot mandate the disclosure of code in those contexts. Rather amazingly, we've also got internet governance provisions here. There are requirements for all country code top-level domains within the TPP, and I should disclose that, as you heard, I'm a member of the Canadian Internet Registration Authority, board member of CIRA that manages the .ca. We operate independently. We have an observer status for Industry Canada, but as a board, it's a $20 million a year in revenue organization that runs the management of Canada's internet system, a domain name system, by and large independently. Within the TPP, we have now gone and required that all CCTLD operators provide mechanisms for redress with respect to intellectual property, as well as provide access to their registrants, the so-called who is policies. Now, it is unprecedented from a Canadian perspective and for many of these other countries for those governments to intervene directly in the management of their TLDs, their top-level domains, in this way. And it is particularly striking at the very time that the Canadian government and many other governments are trying to reject and urge others from rejecting greater intervention from governments like the Russians or the Chinese within the internet domain name system, that within the TPP, we get intervention on policy when it comes to internet governance. Yet that's what you find within the e-commerce chapter. There are telecom provisions there, and unlike the Canadian Telecommunications Act, which includes prominently privacy and security-related issues as one of the priorities, it is a subordinate issue within the TPP. It's simply not seen as important in that context. So there is a lot, I think, in there. Let me just conclude by sort of asking that question, well, does any of this really matter? Now, I obviously think that it does, and I hope that many of you will as well. I think it does for a number of reasons. First off, there is real liability risk here. So we have included within the TPP, perhaps one of the most controversial aspects of this is the investor-state settlement dispute system that allows companies, private companies, to essentially go and seek redress and compensation where they argue that their investment has been harmed, and that is a result of the rules within the country that are non-compliant with the TPP. Now, this is something that we already have experience with here in Canada. Now, frankly, I don't believe that ISDS-style provisions have any place in agreements that include countries like Canada and the United States and Australia and others that have reputable court systems, and if you're seeking redress, you can go to our local courts. Instead, this provides an alternative mechanism, one that we have recently seen in the context of Eli Lilly, results in litigation on patent issues running into the hundreds of millions of dollars, saying that Canada, you're responsible and you owe us hundreds of millions for rulings coming out of your courts. Now, I know that government officials are confident that we will ultimately win that, but what the TPP does is take those kinds of cases and extend it broadly. We again had just this week some publisher groups argue that Canada is offside its obligations when it comes to our fair dealing rules. Will we see an ISDS challenge from large international publishers arguing that they've lost revenue on the basis of our existing rules when it comes to copyright and seeking compensation? Will we see ISDS challenges on our privacy rules, where the Privacy Commissioner seeks to establish certain standards to better protect the information that gets protected, let's say in the aftermath of Ashley Madison or something like that? They say, these are the new standards that you now have to have. And a company says that's in effect creating a data localization rule because you've got to meet those higher standards, and we're going to bring an action against you. Will we face further kinds of claims based on the aftermath of the US-EU, the legal challenge to the US-EU safe harbor agreement, which is going to, it seems, restrict the ability to transfer data between the US and the EU, and it is in all probability the case that we may face similar restrictions about data coming from the EU to Canada that ultimately may make its way into the US. Is that also going to be subject potentially to an ISDS challenge? Because in the TPP, we've agreed to stop or to eliminate the prospect of blocking data transfers. These are real risks, and they come as financial risks. And ones that, if we take a look at what we've seen around the world, both here with respect to patents, tobacco and the like in other countries, there are real risks associated with this. But beyond that, though, the isolation of Canadian rules, I would argue, ultimately serves to isolate Canadian companies. And so we go through policy processes in Canada that seek to develop rules that sometimes I think are best of breed. Spent a long time talking about how the Canadian rules in this context through open processes are sometimes better than what you will find elsewhere. And we get Canadian companies often ramping up to ensure that they're compliant with those rules. And yet when they now seek to embrace the opportunities presented by agreements like the TPP, they find that it is not reflected in the TPP, and suddenly it's either abandon those Canadian rules, which is of course the goal, as we saw the US quite plainly stating, or face dual costs of having to comply with Canada and comply with TPP standards as well. But even more, I suppose, at the end of the day, from my perspective, the downgrading of Canadian policy ultimately represents a downgrading of our country as well. It's a country that when we talk about the importance of digital policy, its future for innovation, its future, quite frankly, for the full economy, for society as a whole, and the effort that so many have spent to make those issues relevant and forward-looking, and then come up with a trade agreement that, by and large, doesn't represent many of those same policies and values, that the best we can do is adopt a prevent defense, and let's hope to preserve what we can, but not see some of those same kinds of ideas and principles reflected more broadly in the TPP, I think that represents a real mistake. We've heard a lot over the last number of weeks about Canada being back. We're back on the environment, and we're back about providing access to science or freeing our scientists from speaking again. I think the TPP is going to provide a really important test to determine just how back we are. We need to ensure that at a minimum we have truly robust, open hearings about this that are something more than just theater. Quite frankly, if we go in with the only possibility that you either accept or reject, and that there is no prospect for change, then by and large this will be, I think, theater, or at least I fear this will be theater. I think for Canada to be back, for Canada to ensure that the agreements that it signs not only reflect the policies and principles of the country, but also put us on the road going forward to the short, medium, and long-term future, we've got to have a really, truly robust review, and I think even more, work to ensure that the final TPP, the one that we actually sign, because we still haven't signed anything, is one that is far more a made in Canada type of agreement, not what we're currently facing now. Thanks very much for your attention.
Thank you very much, Professor Geist. That was a real tour de force. And I was going to say before we started that the International Law Research Program is looking for research topics. But now I almost regret that thought, because it seems like we're really at the beginning of a lot of work here, and there's lots more to discuss. So now we're on to our panel. So I would ask that the three panelists please come forward, and I will introduce you. So we have Myra Torfik, who will speak first. She's a senior fellow at CG. She is working on topics related to the cost-effective and meaningful provision of intellectual property legal services for startups and entrepreneurs. This project will develop a set of recommendations about best models and practices for providing a comprehensive IP and business law service within the public sector entrepreneurial support system. In addition to her role at CG, Myra is, of course, a professor of law at University of Windsor, as well as the academic director and founder of the Law, Technology, and Entrepreneurship Clinic at the University of Windsor, and was very instrumental in us holding our summer student clinic this year. She's been recognized for her research excellence and activity with CG by the University of Windsor, and Myra is a former associate dean from 1998 to 2000. And she's the editor-in-chief of the Windsor Yearbook of Access to Justice. To Myra's left is Warren Clark, who is a senior research associate, Center for Digital Entrepreneurship and Economic Performance, or DEEP, which is easier to say. Warren is the senior research associate there. His work includes a focus on the relationship between large and small firms, the politics of intellectual property, and the evolving role of the state in the control and regulation of the economy. Warren holds a PhD from Balsillie School of International Affairs, where his research focused on international institutions and global regulatory politics. And he was previously a doctoral fellow at the Center for International Governance Innovation. Barry Suckman, at the far end of the table, is senior partner with McCarthy Tetro in their Toronto office. He's a former co-chair of the firm's technology law group and was the head of the firm's Internet and Electronic Commerce group. Prior to that, he was head of its intellectual property group for 6 years. He is one of Canada's foremost authorities in the area of information technology and intellectual property law. And I should also mention he's a member of the advisory committee that supports the International Law Research Program. So without more, I will turn over to Myra.
Thank you, Una. Thanks. Just to add, I wanted to just say, so that I'm fair to my colleague, who's now the current editor-in-chief of the Windsor Yearbook of Access. I stepped down, so that just to make that clear. Michael, in his very provocative talk, asked us really how do we get more Canada into the international trade agreements, especially in relation to the various kind of the digital agenda and the intellectual property chapter. I guess my comments relate to what happens if we don't get more Canada into those agreements. And I'd like us then to think about what we do in an environment that's skewed. It's very sobering, obviously, to listen to our discussion over the TPP and for me to tell you that throughout our copyright history, Canadian copyright policy has always largely been determined by outside interests. It started well before Confederation. And it led, for example, one commentator in 1896 to lament that the interests of Canada, so far as copyright is concerned, have been cruelly sacrificed for the last 50 years. And here we are today still lamenting this cruel fact over 120 or 130 years later. So my point today is that we have to change this narrative. We need to understand completely and fully that international intellectual property rules are manipulated by power and politics. We need to recognize that international trade in IP, that the regime isn't really free, nor is it fair. And we need to determine the implications of this reality on Canadian interests, Canada being a middle power in a larger geopolitical framework over which we've had and continue to have little influence. So how do we change our narrative? I think, first of all, we need to be smarter about understanding, and I'm going to speak specifically about copyright law, but it applies right across the board to our intellectual property laws more generally. So we need to be smart about understanding copyright law and its impact or impacts on various Canadian stakeholder interests. I mean, Michael alluded to this New Zealand study where they went and they did an assessment of the impact of term extension on New Zealand interests. We need to be doing that here. We need to understand that very often what we think copyright law is doing, what as a matter of policy we want copyright law to do, isn't necessarily what it's actually doing on the ground. And we need to study this more closely. I mean, there are countless examples from the history, and obviously you get a sense that I'm kind of deeply interested in understanding the early stages of the development of Canadian copyright law. But Canadian copyright law at its beginnings didn't actually privilege authors or the users. I mean, publishers were the first to benefit, and it didn't result in greater varieties of books for the reading public, nor did it result in costs coming down, book prices coming down to consumers. Data from the UK and the US suggests that, again, in the 19th century, so we're back in time, but I think there's a relevance here, book prices didn't come down with the advent of copyright. What happened was prices did come down, but it was closer to 2 years before the copyright was set to expire. So you can ask yourselves, if you prolong it by 20 extra years, what will happen in terms of consumer prices, assuming that by life plus 70, there's still enough people interested in the books that are being published today to really care. But cost savings weren't passed on to consumers. Now, I'm not saying that history gives us all the answers, but it does tell us that what we think copyright does may not actually be what it does in practice. And in Canada, we haven't been very good at studying these questions. Copyright is in the eye of the beholder very much. It depends on whose vantage point and which interests, creators, industry, the public interest in access to knowledge, the public interest in economic benefits, depends where your focus is. It lands on different kinds of creators, different kinds of public interests, different industries differently. So before we make any determinations about the impact of the TPP on copyright, for example, we really need to make meaningful determinations about how copyright affects each of these groups and subgroups. The second thing we need to do is to fully understand the copyright IP trade-off we're making in the TPP. I mean, Michael said, obviously, it's a much vaster agreement. It's not just a standalone IP treaty. So what is it that we're trading off? If we are trading off in our IP, what benefits are we getting? So I looked at the Foreign Affairs Trade and Development Canada website. There was a press release, Canada concludes free trade agreement with Trans-Pacific partners on October 5th, 2015. And what I learned was that the TPP gives Canada preferential access to dynamic and growing Asia-Pacific markets in such sectors as agriculture, agri-food, fish and seafood, forestry and value-added wood products, metals and mining, and manufactured industrial goods. So maybe that's it. Maybe it's good for us. We're trading off some of our IP autonomy over IP for these other industries in which we have competitive advantage. I don't know, but we at least need to understand that a little bit better. The problem I have with that statement, though, is that all of those industries are really reflective of a 20th century economy. They're not reflective of, and we don't see ourselves. In other words, IP isn't mentioned in this statement. It wasn't a win for us. So we obviously don't consider ourselves as players in the knowledge economy in which IP is the global currency. So we need to shift our thinking and recognize the importance of IP as an essential feature of a modern Canadian economy. And if we were thinking about ourselves as players in the knowledge economy, wouldn't have necessarily appeared to be so cavalier about how we dealt with them within the context of this larger international trade agreement. So this has to change. And finally, the third point I'd like to make is that even assuming we can't do anything to change the TPP, okay, we need to figure out how to use this skewed system to our advantage. We need to sort of therefore develop the strategies in order to be able to compete effectively in a knowledge economy in which intellectual property rights become of increasing importance. We may not be able, we may have no wiggle room to get out of this agreement. So, and I suppose the debate or discussion in government today would be, do we can we afford to pass up the opportunity for more liberalized trade in the Asia-Pacific region, regardless of how flawed the agreement may or may not be on IP? Perhaps it would be better, it's better for us to join this club rather than to be excluded. In some of the provisions, for example, the term extension, as Michael said, whether or not it's in the TPP, it's coming anyway. I mean, the pressure in the international world on us is sometimes, I think, very difficult to sort of push back, or impossible to push back. If these rules don't see the light of day in the TPP, they'll likely appear somewhere else down the road. So where does this leave us? So if we have little influence in international negotiations, my point is that we need to recognize and be prepared to counteract the fact that the field is not level in this international IP space and that the system isn't fair. Not only are the rules skewed in favor of more powerful countries than ours, that the way these rules are operationalized in practice further exacerbates the inequality. And it's the sort of, and by that I mean, for example, international litigation practices, the ways in which, customs within different kind of industry practices in different countries, lobbying, all those things that, as a matter of research, issues we tend to overlook, but have a great influence or an impact on shaping not only the rules themselves, but how they operate on the ground. So we do have control, at least. If we don't have control over the text, we do have control over how we hit the ground when those rules come into place, and we should hit the ground running. We need to develop more sophisticated practical strategies to enable our creative communities to thrive and prosper in a global environment, even as we recognize and acknowledge the inherent inequities in the international trade and IP system. We need to understand what it actually means for Canada to be competitive in a knowledge economy, and this, of course, takes us back to how we view and protect our national IP interests in an international environment, and we haven't been very good at assessing that to date. So if we want to avoid another century of lamenting over our cruel copyright faith, we must together, industry, the academic community, entrepreneurs, our creative classes, we must figure out how to become bolder and smarter about mastering the global copyright game. Thank you.
Well, thank you, Myra, and thank you, Michael, for, as Una said, a tour de force in helping us understand sort of some of the many provisions in this very long document. My first comment is very simply on language, because I think language and history is important. And I want to stress that we need to finally move beyond talking about these types of deals, such as the TPP, as trade deals. I mean, these are not trade deals, at least not exclusively. These are agreements on economic policy harmonization, and these are agreements on international governance. And whatever we decide as we continue on our domestic debate, we should discuss them as such. And I know many of you in this room are going to be familiar and aware of the history of how these types of agreements have evolved, but perhaps just for the benefit of those who are not, I think it's also equally important to realize that the linking of various issues with international trade, as we typically conceive it, of the movement of goods across borders, is not something that has happened naturally and is not something that has happened necessarily by accident. In fact, if you think about intellectual property specifically, it's actually very much in many ways antagonistic to the idea of free trade. Free trade is about freeing up the movement of goods. And intellectual property protections are about setting up barriers to the free flow of ideas. So why do we associate these together so strongly? I mean, why do we think that every trade deal is going to have an IP chapter, as they do? We do this because there's been a long-standing and very effective strategy on the part of powerful interest groups within the United States who realized as far back as the 1970s that they were never going to achieve their desired outcomes with respect to maximizing intellectual property protections abroad through standalone agreements or through negotiations through the World Intellectual Property Organization. The question of policy harmonization was never going to be a winner. But if the question could be tied to support of free trade, their potential for success would improve exponentially. And ultimately, I think this has been a very successful strategy since at least the late 1980s. And because of that, it's a strategy that we're going to have to wrestle with, and it's a strategy that's not going away anytime soon. But I do think that it's something that that linkage is something that we should continue to be interrogating. And it's not just a question for those who are typically concerned about these types of agreements in general. It's also, I think, a concern for people who are in favor of free trade. Because there is an argument, and I think it's not a bad one, that part of the reason that we've seen such a stalling on the international trade agenda in the past number of years is because of this sort of desire to bring in all of these different issues and attach them sort of as riders and difficulties over IP and other linked issues as well. Now, with respect to the specific provisions of the TPP and the question of whether this is good for Canada, that's a very complicated question, and I don't profess to have an answer. I mean, does enhancing market access for our agricultural producers make up for losses for the public domain? I mean, I'm not sure. But I would argue, and what I would argue quite strongly, is that that's a question that's worth taking seriously, and because of that, it's not one we should rush to judgment on. I think the most important thing that policymakers in Ottawa can do right now on the TPP is slow down. There have been some reports that in late October that Prime Minister Trudeau was already in discussions about supporting the passage of the TPP. And I think that would be a mistake. Given the breadth and scope and complexity of this agreement, we should have a robust public debate and a robust process of expert review. And my reading of the way that the agreement will be implemented is there's no reason why we can't have that. If you look at the ratification formula and the way that the deal is structured, the agreement will enter into force when either all of the countries have ratified or after 2 years, after 6 or more countries have ratified, representing 85% or more of the collective GDP of the group. Now, the US alone accounts for over 60% of that weight, giving them an effective veto on whether or not this deal will proceed. And any of you who have studied sort of either U.S. history with respect to trade or have been following the public debate in the U.S. will know that passage of this agreement, despite the fact that the President has been given trade promotion authority, which will force the Congress to vote this deal up or down, passage of this deal in the United States is not guaranteed. So at the very least, I think we should wait to see what the outcome is in the United States before moving on this in Ottawa. My reading is that the passage of the deal in the U.S. or the vote on the deal in the U.S. will wait at the very least until the spring. There's sort of an April window, which is the timeline that's being promoted, but could very likely fall into the fall. At which point, I think there's no real reason for Canada to move on ratification until early 2017. In addition, my final comment on this is that Canada's relative economic weight in this agreement is actually not inconsequential. We're the third largest signatory country with respect to GDP. And depending on how ratification plays out, Canada's voice could matter and could be important in deciding whether this agreement goes forward. The US and Japan can almost reach the threshold on their own, but they'll likely need one of Australia, Mexico, or Canada in order to push the agreement forward. Now, my reading is that Australia is very likely to be supportive, but at the same time, I think it is worth, given the possibility that Canada will have to make a very important decision, and in any case, we'll have to make the decision as to whether or not to participate. It's worth giving due consideration and expert review on these questions. Thank you.
So like Michael, I want to start off by thanking CG for holding the event and for being a unique Canadian forum where ideas can be discussed and debated. There really isn't a forum that has this capability, so I just wanted to use this opportunity to thank Jim and CG for making all this happen. And again, Mr. Honorable MP, again, congratulations. I think it's wonderful to have someone who knows IP in Ottawa. And thank you, Michael, for starting off the debate, which I'm sure is going to go on for quite a bit of time, not just on IP, but on the other aspects of the treaty. I think part of Michael's theme was that Canada engaged in a prevent defense posture, and I think there's no doubt that that's true. And when you look at this particular treaty, it's quite different from other free trade agreements that the United States has entered into. So the prevent defense was actually fairly effective in this case. But keeping the analogy to to sports, sometimes the best defense is also the best offense. And in this case, by pushing as much as Canada obviously did in this arena, there were some major changes made that now will have international implications that will, in fact, create the capability to export kind of made in Canada solutions. Not every single one of them, but made in Canada solutions. So I actually disagree that the prevent defense wasn't effective completely, and also that it won't have positive effects around the world. I mean, let me give you some examples. Michael, you talked about the Canadian exceptions in copyright. The treaty expressly retains the three-step test, which permits wide flexibility in terms of exceptions. It also lists very specifically just about every major exception we have in fair dealing as a specific purpose that would be the subject of an exception. You talked about Marrakesh being left out. Well, in fact, in Article 1866, specifically says the parties will endeavor to, that has a number of things, and one of them specifically refers to the Marrakesh Treaty. So it clearly is a policy objective to have a broadening of the exceptions, which you don't see in other U.S. agreements, and which was expressly recognized. And I'm sure that's because those who were at the table, and because the Canadian government had announced an intention to adopt Marrakesh and had a bill before the election. So I think the doors are pretty much open on that. You also talked about TPMs, and you can see the Canadian fingerprints all over the way the TPM provisions are written in the TPP. For example, on criminal remedies, you see exceptions for libraries, museums, archives. You see exceptions with respect to civil liability. Again, these things, when you look closely, are really emanating from Canadian law. The same thing on statutory damages. Take a look at it. We don't have to implement it. We have exemplary damages. And that's an example where now all the other countries who adopt it don't have to implement statutory damages, because many of their laws will have the ability already to award additional damages or exemplary damages. The ISP annex, I think it was not reasonably possible to construe that annex as ever requiring notice and takedown in Canada. In fact, the wording was right out of the statute. And in fact, if you look at it carefully, the wording uses almost exactly the wording as you had described it in a 2005 blog you did right after the wording was in C60. So I actually don't see it. As far as the investor-state regime is concerned, these things are not new in trade treaties. We have it in NAFTA, we have it in CETA, and we have it in 30 FTAs or FIPAs. So again, this is a common way of addressing requirements to ensure that treaties are enforceable. The key question, I think, that you are raising is this regime good or bad, right, at the end of the day? And that's something, obviously, that the Canadians will clearly need to debate. And I think when you're looking at that, there's really two questions. The one is, what's in and what's out? And so, in terms of the what's in, if we're going to thrive in a knowledge economy, then we need to have a regime that creates incentives, creates markets, so that corporations can make investments, corporations can enforce their rights. All of those things are needed in markets. And this particular treaty does reflect our alignment with our global trading partners, the Europeans, the Americans, and others, in terms of what is understood to be the proper way to create incentives so that there will be an investment in the knowledge economy. And one might ask the question, if you look at the US regime and you look at the Googles, the Facebooks, the Ciscos, the Microsofts, the Apples, and all the successful companies, how are they able to do well in a regime that you say is not the regime we ought to have in Canada? So I think there's some good arguments that the balance that's reflected there is the international balance and actually will provoke an innovative economy. What's not in the treaty is anything that allays what happens on the ground, such as in the US. A major problem that Canadian entrepreneurs have in the US is dealing with the US patent system. Not only is there trolling, but there's a huge bias against any foreign business. It probably is unlikely to think that the TPP could change that given the realpolitik of how treaties are engaged in. So there is a difference between what the treaties do and the framework they create and then what happens in the ground when Canadian innovators hit the US market. And I think that's something that does need to be discussed. It needs to be put on our agenda, and we need to find a way to address that. But that is, in my view, not integral to whether the TPP ought to be supported or not. I mean, these are two very important issues, all of which should be on the Canadian agenda.
Thanks very much to the panelists. That was very interesting observations. And Michael, you have an opportunity to say a few comments if you'd like. Keep them fairly short, I would ask, because I'm hoping there's some questions from the audience that have gathered. So folks who are the gatherers, please harvest right now. Bring them up while Michael is making his comments.
Great, thanks. So I will be quick. And thanks to all three of you for some really great comments. I'll quickly try to address or give a couple comments in reverse order. Barry talked about the system being what is understood to be the way to do this. That's the same kind of comment we heard a lot during the copyright reform process. We hear about it, frankly, on every agreement. And what is understood is simply, by and large, what large U.S. companies have been saying is the way to do this. I don't think the evidence suggests that it is. It's striking that you would point to that Marrakesh provision in which we endeavor to move forward on Marrakesh. Had it said endeavor for the WIPO treaties and for the myriad of other treaties that are in there, then I would be in total agreement. But it's clear that we take one group of treaties and mandate them. We take different kinds of treaties, and we clearly do not. There's other things I would say, but we'll save it. With respect to the great comments on timing, I'm totally in agreement on this. There is no reason to move forward on this until it's clear that the United States President Obama has made it clear he plans to sign. He's provided notification that he will sign within 90 days. That's something quite different from ratification. But I would note that I don't think it's true that all treaties necessarily mean that we're moving in the same direction. And so to take term extension, again, as an example, the Europeans started by asking for term extension within CETA 2, and they didn't get it. If you look at the Canada-Korea deal, you find a lot of the kinds of provisions there aren't reflected in the TPP. I don't think, and there we have a major Asian economy, I don't think it's the case that it's simply a foregone conclusion that the kinds of things that we see in the TPP are what you're going to get in trade agreements. These agreements vary, and our negotiators actually in the past have been quite successful in trying to do a better job of not seeing some of those things chip away. Finally, I love the historical references that Myra provides, but it leaves me at the end of the day feeling, well, a little depressed about it all. If this all comes down to history always repeats itself,
it's all going to happen anyway due to pressures, and we're just a minor power. In the parlance of the moment, I'm going to adopt a sunny ways approach about this stuff, and suggest that I don't think that's the case. I think that what we've seen over the last decade in Canada is that it is possible to do these policies differently, that it is possible to say that there can be made in Canada approaches on these, both in the way that we make these policies and in what these policies ultimately look like. And I'm hopeful that this isn't just a blip, that we'll look back at some point in time and say, that was a little fun stretch when tweets and Facebook postings could begin to have the effect of getting politicians to take notice and beginning to influence policy, but we're instead rather the start of something that others begin to emulate more assertively, recognizing that these are issues that matter to all, not just large US multinationals that have much of the lobbying muscle as part of this debate.
Thank you very much. So let's start. I've got a ton of questions, so let's start right away with the questions. First one is a bit of an odd one because it's going to just open up the discussion a little further. And that's a question about human rights. And this is for you, Michael, but maybe others want to comment on it. The question is, where is democracy in this trade agreement, and where is human rights in it? Is it relevant or is it not relevant?
Well, I think given the sheer scope of the agreement, of course it's relevant. There are provisions on things like labor. There are provisions on the environment. There are provisions on access to medicines or impact on access to medicines. These are all, from my perspective, fundamental human rights issues. If you take, I don't profess to be an expert in these issues, but if you read what the Sierra Club is telling us about the implications on the environment, if you take a look at what many experts in the labor field have talked about, what this will actually mean from a labor standards perspective, and if you take a look at what Doctors Without Borders and some of those other groups are warning will be the impact in terms of access to medicines in some of those jurisdictions, the impact in many of those countries will be profound, and I think profoundly negative. And recognize that the TPP starts with these 12 countries, but it is by design an effort to try to get other countries on board as well. We've already had some of the other Asian countries who are not participants, such as Thailand, talk about the prospect of joining on. And so the impact, particularly in countries that are still moving along the development curve, could truly be profound.
Anyone else want to comment on that? Or?
I'll just make one comment on the human rights, and then to tie it back to the IP provisions. There was a Supreme Court of Canada case decided about a year ago called Robinson, where the Supreme Court found that copyright was protected by the Quebec Charter of Rights and required effective remedies to effectively protect the human rights of individuals. So the treaty, in one respect, although it's not tied to it, is consistent with the requirements under the Quebec Charter, which, by the way, there's similar charters around the world that have also viewed IP as a human right.
I would just jump in and say, I mean, to some extent you could say that the democracy is yet to come. That's why we have these ratification provisions. But I think if you want to take a fuller understanding of what democracy is, it's based on awareness and about an understanding of what's in these sorts of agreements and about a real serious societal discussion about them. And I think if I can borrow from Michael too and be a little bit more optimistic, I mean, we have seen progress on this over the past number of years. And if you think of way back to sort of 1995 and the trade-related aspects of intellectual property rights agreement, there was very little public understanding or public discussion about the types of implications that an agreement like that would bring. If you fast forward to the anti-counterfeiting trade agreement and what went on in Europe and elsewhere in response to that, I think you see a real rise in public awareness of the potential implications of these agreements and quite a bit more robust involvement from civil society organizations in doing that. So I think that's positive. And so that type of process is essentially what we need. I'm kind of the opinion that to some extent when you're negotiating agreements, you do have to keep the doors at least a little bit closed. Now there's different ways of doing that, but you can't have full involvement the whole time. But on the flip side is you do need to open that process up at some point, and we're in that point now.
So I have a question here about leverage. To what extent does acceptance of the TPP provide non-treaty nations leverage with respect to market access, etc., without holding them to the same provisions? Does anyone have any comments on that?
I wasn't totally sure. I'm not sure I totally understood.
Or lack of leverage?
Well, I think that I think it's the reverse, or at least that was
You
the.
think.
I think that was. I think
You
that
would
was.
think.
If I understand the question, I mean, the general perspective was, especially when Canada was outside the TPP and made a concerted effort to try to become part of it, was that it was better to be inside the tent than outside, and you could hope to try to influence the treaty. And Barry's tried to make the argument that we did. And obviously, if you take a look at some of the earlier leaks, Canada did stand, at least initially, on many of the issues, certainly within the IP chapter. Some get reflected, some don't. Perhaps that's part of what negotiation is. But I'm not sure that there was an advantage for countries to be on the outside, though.
So I totally agree that Canada made the right choice to join the negotiations because it actually was able to influence quite substantially the way the treaty ended up working out. And if we'd come in later, we would have had no leverage. I think Canada definitely made the right decision. In terms of the position of non-parties, obviously they can join. The treaty only requires national treatment, so technically it won't apply to non-parties. But if other countries change their law, they may very well simply make them generally applicable. So to that extent, non-parties will either take the benefit or take the loss, depending on how you view the provisions of the treaty, because they'll probably apply to any national, at least on IP.
I just wanted to quickly comment on the idea that you do need sometimes doors closed as part of trade deals. And I can well understand how that might be the perception on issues where we're negotiating. Well, what's the level of tariff reduction on a certain kind of fish or something like that, where that's just a basic commercial negotiation. But I alluded during my talk that we're talking about a lot of issues that are actually not of that nature at all. Issues that frankly, having far more openness would have, I think, benefited the treaty. And conventionally, when we've talked about those agreements or those issues, they have been open. But I think it should be noted that in the do as I say, the category of do as I say, not as I do, Canada, by and large, to my knowledge, didn't do any leaking. Certainly didn't do any leaking to me, and didn't involve whatever groups in some of the direct negotiation. But that's not true for the United States, which had pharma representatives on the ground in Atlanta with active briefings as they're negotiating it. And so it may have been closed for a lot of people, but it wasn't closed for the United States, which strikes me as just as sort of an incredible way to go around negotiating things, where they have these advisor groups that are able to gain full access, to the point that at one point immediately after the treaty, I tweeted out something about one of the implications, and a representative from the Canadian Chamber of Commerce tweeted back saying that in fact there was an exception in the agreement. Well, that agreement at that time hadn't been leaked and hadn't been made available, and I never made a fuss about it, but I found it quite striking that the Canadian Chamber of Commerce, presumably allied and working with both the US Chamber as well as with many of those representatives, had access to information about agreement that frankly nobody else did. And creating that two-tier structure as part of the negotiations is part of the problem. One of the reasons why it benefits everybody if it's an open process for all.
So just on the open process on transparency, if I can just deal with it quickly, there's a real problem today, I think, about balancing the objective of reaching an agreement and being fully transparent. I mean, if you look at what happened when there were the WikiLeaks disclosures, much of what the commentary was inaccurate and misleading. And so if you would have had a situation where there was a lot of disclosure before things were actually settled and agreed to, you run the risk that the whole trade deal would have been completely gone off the rails. And so I agree about the need for consultation. We hopefully trust our governments and their ability to understand what the issues are and to represent Canadians. But there is a real problem in this day and age with social media and with those who simply would pillory something and not do it accurately, and there's no way for a government who's negotiating to defend. So I just kind of raise that as a policy question. How could it really have been done successfully?
I'm going to move on to a few more of the questions. You're picking up a number as you discussed, so it's all going well. So here's a question. If Canada rejects ratifying the TPP, presumably after a process of evaluation, what does Canada have to lose in terms of copyright and related areas? Do you want to go, Brian?
Sure.
Or Myra? Sorry.
Go ahead.
So that's a good question, because I mean, by and large, Canadian law already reflects a lot of the provisions in the TPP because of the history that Myra talked about, and in fact the history that Michael talked about. There's been successive amendments to the Act. We're party to most of the treaties. Many of the provisions in the TPP, in fact, simply recite various of the treaty articles. The way it was structured, unlike other treaties, is not to say the parties will comply with the WCT, the parties will comply, it's they will have exceeded. So it doesn't incorporate them by reference, it's simply a standard. And that's why you actually see provisions that are set out there. So Canada, by and large, has most of those provisions, and frankly, has the flexibility to continue the Made in Canada approach, whether it's in or not. Where we are potentially disadvantaged is in our ability to have national treatment in other countries. And that's important for an industrial economy. Now, we may or may not succeed in a major market, maybe continue to be the United States, maybe Europe, but if we believe that there are great economic opportunities that Canada has to try to be successful at in the East, or the Far East, then this is fairly important. And then if you think that the TPP is a stepping stone to India and China as the next step, as it may well be, then Canada not being a member to this means Canada won't necessarily get advantage to the favorable treatment in those other countries. So I think actually there's a potential for a big loss.
We should note that Canada already has trade agreements with many of the TPP countries. We already have trade agreements, obviously, with the United States and Mexico. We have it with Chile, have it with Peru. We have a South Korea one, which is, as I mentioned, is not even part of the TPP. And so the notion that there is lots to lose within the context of the TPP is really only true with one. There's only one significant economy that we don't have an agreement with in the TPP, really significant, and that's Japan. I mean, Australia may provide some value, but it's not major from a Canadian trade perspective. It's really only the Japanese market, and we were in the midst of negotiating a Canada-Japan deal as well before the TPP came along. So it's true that we'll be on the outside of certain countries. We're still on the inside for most of the major ones within the TPP, and the idea that China is rushing to sign up on an agreement that by its nature was designed to establish a trading bloc to counter China strikes me as something that isn't a short-term, or frankly even a medium and almost long-term risk.
Myra, did you want to comment
Yeah,
on
I
this
just,
one?
I just wanted to add, part of what we're discussing is exactly kind of the point I'm trying to make, which is that I am talking about changing the historical narrative. So, looking at sunnier ways if we can, but recognizing if we are constrained by these limits, what is it that we can do to actually change the game or change the field if we are so disadvantaged on the face, as we enter the field. And part of it does become this question of what we gain if we become a member of, if we open up sort of the Far East sort of in terms of trade. I mean, if we look at the layering of these treaties, like Michael says, we already have a treaty with Korea. We already, so why are we doing all of these things? I don't think we do enough to try and understand the implications of our actions. I use the word on the ground, but empirically. We don't think enough about understanding what the impacts are. So if we are sort of, going to Life Plus 70 or whatever it might be, but we are gaining access to greater markets, let's understand the mechanics of how that works and let's use them to advantage. And that's it's another layer of study or analysis that I think my sense is we're weaker at, and we need to start to to think more strategically about how we manage from plan A to plan B to plan C, whatever it is, but that we need every layer of information and evidence so that we can make informed decisions regardless of where we end up positioning ourselves with the TPP inside out, if it collapses or doesn't.
Myra, thanks
Yeah.
for that comment, because there were a few questions here which related to how TPP relates to the CETA, how it relates to WTO, and have we covered this off? Do people want to talk more about the global trade environment?
Can I just jump in
Sure.
very quickly on that? Just have a quick comment. I mean, I think it's important to try and look at this holistically within the context of other agreements. And I'm not sure that we've done enough of that so far. One of the interesting things with NAFTA, I mean, just going back to the initial question, I mean, I tend to agree that is the winners, if we talk about the winners in terms of sectors, are definitely outside of kind of the IP space when we're talking about TPP. And when we talk about, a lot of the proponents of this agreement are saying, well, we can't give up our preferential market access to the United States. And so you raise the question is, how will this work with NAFTA in a host of other areas? And I'll just raise one example with respect to automotive. I mean, how will changes in rules of origin in the automotive sector impact the ability of Canada to bring in and entice original equipment manufacturers and big auto plants to locate in Ontario? I mean, that's part of this discussion as alongside of the IP discussion. So when we're talking about whether this is a good deal for Canada, it's an enormously complicated question, because you need to ask how all of these various different parts of the TPP interrelate, and then go out and say, how do they interrelate to all of the other agreements that we're already engaged in? And so trade scholars usually use this sort of spaghetti bowl to try and put these things together. But it's complicated, and that's why I think we need so much time in order to tease out what those various different interconnections are.
Thank you very much for that. We've run out of time, so I'm going to ask you one last question, if you can think of one answer to it. What do each of you think is the most pressing issue to be looking at right now with respect to TPP and copyright in terms of research? Who wants to go first?
Don't ask an academic that question.
There's many. It depends. We won't ask the economists either. Are you ready to?
Well, I think the biggest change that we face is term extension, and I do think term extension represents, particularly in a digital environment when there's the prospect of really breathing new life into works, using those works within education and the like, represents not just an enormous economic cost, but a significant cultural cost as well. That just about any serious economist that has looked at this represents no real gain. In terms of the beneficiary, certainly from a Canadian perspective, but there is a real cost. We need to do better than just doing those scans, though. We need to know what the cost is, because we had a government that was willing, the last government was willing to hand out billions of dollars to dairy farmers. But what about the costs that come from some of these other kinds of agreements or provisions?
I'm going to cheat a little bit and say that, I mean, for me, the biggest question is how this works holistically, and what the balance is and what the cost benefit is between some of the parts of the agreement that I would certainly agree with Michael in saying. I mean, the copyright extension doesn't seem to have any benefit whatsoever. There are other areas of the agreement that do. How can we work out that balance? How can we determine that value? And are there other remedial steps, if we do decide to sign on, that need to be taken to balance that out?
So my message would be, to all of those questions, we need to find the answers. We need to be able to sort of demonstrate that, that we have an informed way of answering all of those questions. So that's my big research agenda.
Okay, so I got just a tiny response and then my point. On term extension, I think that issue has been completely overblown. The image that gets conjured out is every book is getting pulled off a library and is going to get stored along with plutonium underneath a mine somewhere, and it'll be shackled, and those books will never be read again because they're actually protected for another 20 years. And that's not the case at all, because copyright only protects expression, doesn't protect ideas, and there's lots of exceptions. 90 plus countries around the world have 70 plus years, including all of our trading partners. And I think you said no economist, Michael. Well, I guess you don't include Landis and Posner or Professor Boyer, who did a study of that for Industry Canada. There's a bunch of economists who would actually disagree with you on that. At least there's a debate. It's not open and shut, as you say. The New Zealand study you referred to was one line on a website. The study hasn't been published, nor do we see when today?
Yesterday.
Oh, yesterday. So, but you've got to look at the assumptions in the study, because those assumptions are really key. Is it assuming a closed economy or an open economy? And then are they assuming that in fact prices go up or down, when in fact, there's an EC study that says prices don't change at all. So, those numbers could be zero if the PwC study on that is actually right. But to go to your question, I actually think that the most important thing that we can do is to focus on substantively what the treaty requires, and move away from rhetoric, move away from broad sweeping generalizations, and actually condescend to the specifics of the treaty, to have a rational, informed debate, both in the media and before Parliament, so that what gets debated is not things about the treaty, but specific provisions of the treaty. I think if we can have that kind of rational debate, then we can make an informed decision, and it's going to be yay or nay. But I think that's what we need. We really need to think about what it really says.
Thank you very much, Barry, and thanks to all the panel for really insightful comments. I'm going to turn now to the Honourable David Lametti, newly elected MP for La Salle-Aymar-Verdun in Quebec. David's going to say a few words of thanks to the panel and to Michael in particular. Thank you.
Thanks very much to all of you. I'm not honorable until I actually get appointed to cabinet or something else. So I'm not. I would put it as I'm not honorable until I've earned it. So I haven't earned anything yet. Excuse my cold. Thanks to all of you for coming out today. First of all, I'm going to thank the panel. All leaders in Canadian intellectual property and copyright circles. A newer arrival, and you're very welcome as well. And thank you for your comments, Warren. I want to put on my Democratic hat to thank Michael today. You all know his accomplishments as an academic, and as his keynote address today showed us. It was a tour de force, and it oriented the discussion and the comments that came afterwards. But I want to thank Michael on my new hat as a member of Parliament, and therefore as a Democrat. One of the things that I think Michael has done very well is he has been a leader in mobilizing public opinion, individual users on the internet through a variety of different social media and other means to get involved in the political process. I can tell you that during the election campaign, I got a number of both routine emails on IP-related matters and also individual emails on IP-related matters, Facebook messages, Twitter messages, etc. And I can also tell you that I have already gotten both routine and individual emails and social media messages on the TPP and IP, including one on the open source provision. So there is clearly a great deal of enlightenment or a great deal of edification that is going on through Michael Geist's leadership. And as a Democrat, as someone who wants to see people participate in the process, who in particular wants to see young people participate in the process, that is critically important. And I think Michael has been exemplary through a number of different stages of the evolution of intellectual property policy and copyright policy in particular in Canada, and I think we owe that to him. Thank you.
Thank you very much, David. So with that, we are done. Thank you to this wonderful audience for joining us today. You've made this very useful experience for us and very pleasurable. Thank you very much to the panelists and, of course, to our guest speaker, Michael Geist. I think there's still some sandwiches outside if you would like them. And thanks again. Come back for another discussion. All right. And finally, there'll be some closing remarks from the Honorable David Lametti, and then I will close off. And we'll try to do this in a fairly tight time frame, keep things moving. And those of you who didn't get food yet, there will still be food afterwards. We'll cover it up, and you can have it after if that's better for you. Now, about the questions, you've all seen that there's a piece of paper on your chair. We would invite you to write down your questions and then put your hand up. I'll introduce you to 3 people who can help with gathering those questions. They are Aman, Marsha, and Lisa. Could you stand up? 1, Lisa, Marsha, and Aman. Okay, so just put your hand up when you've got a question. They'll gather it, and then they'll bring them up, and that will help us get through more questions more efficiently. Okay, so without more, let me introduce our guest speaker, and that is Michael Geist, Professor of Law at the University of Ottawa. He holds the Canada Research Chair in Internet and E-commerce Law. He is the editor of several copyright books and serves on many boards, including the Canary Board of Directors, the Canadian Legal Information Institute Board of Directors, the Canadian Internet Registration Authority, and the Electronic Frontier Foundation Advisory Board. In 2010, Managing Intellectual Property named Michael one of the 50 most influential people on intellectual property in the world. He's a syndicated columnist on technology law issues, with his regular column appearing in the Hill Times, the Tyee, and the Toronto Star, where he recently commented on Prime Minister Justin Trudeau's technology policy priorities. So Michael will be making his presentation now, so please join me in welcoming him.
Great, well, thanks very much. So if we get the presentation up on the screen, that'd be good. Perfect. Thanks so much, Una, for the invitation, and thanks to all agreement. Indeed, this particular image comes from the U.S. government itself. It's what the USTR, the U.S. Trade Representative Office, is using to promote the TPP. They're not bashful about taking the position that the Trans-Pacific Partnership is fundamentally about taking U.S. rules and finding ways to export them, in effect, to the other TPP countries, including our own. I think that's problematic, and I want to try to make the case for why I think that's problematic in a number of ways. If I had to characterize the Canadian strategy, the negotiating strategy, when it came to the TPP, and of course was not a negotiator, but one can see it come through manifestly, I think, within the text. It is, to borrow a phrase from football, and sometimes I suppose from hockey as well, a prevent defense approach. One in which the primary goal, it would often seem around many of these digital issues, is to ensure that as much as possible existing Canadian law will remain in place, knowing that it will be chipped away in spots here and there, sometimes more than just chipped, but really trying to prevent wholesale change from existing rules, doing very little from an offensive perspective to come in with actual demands or expectations or hopes from a Canadian perspective to see some of those policies better reflected in the agreement. For those that are fans of football, you know that the criticism of prevent defense is that it prevents you ultimately from winning. And I think that is the case here in the TPP, with an agreement that in many ways prevents us from a long-term perspective in achieving what I think would be important policy goals when it comes to digital policy. Now, I want to outline this in 3 particular ways, and I want to start, though, first by at least making reference to the transparency issue
with the TPP. And I readily acknowledge that there is a temptation at this point in time just to, in a sense, let bygones be bygones and say, hey, yes, we had a secretive trade negotiation for many years. I think it would be useful to acknowledge that this is not typical for some of the kinds of issues that were discussed. Trade agreements may at times be negotiated in secret.
Good morning, everybody. Welcome to the CG campus for this presentation. My name's Una Fitzgerald. I'm the director of the International Law Research Program, and it's my pleasure to be your master of ceremonies today. We have many wonderful guests here today from across Canada and from the local region. And I think it's a wonderful opportunity to have a dialogue about these important issues about innovation and international trade. So just a few words about CG. CG, if you have not been to CG before, stands for the Center for International Governance Innovation, and we are a think tank, nonpartisan, focusing on issues of global economy, global security and politics, and most recently, law, rule of law in the international context. And this particular presentation fits into that topic, but obviously touches on all the others, so has a wide range of facets to it. So the topic today is TPP, the Trans-Pacific Partnership, copyright and innovation. And the question is, are Canadian creators or the public interest at risk? I would like to, I'll just give you a rundown on how this session will go. First of all, there's going to be a presentation, a lecture from Michael Geist, Professor Michael Geist. Then we will have a panel with 3 participants, Barry Suckman, Myra Torfik, and Warren Clark. Then Michael will have an opportunity to respond quickly, and then we will open up for questions from the floor.
All of you for coming. There are a lot of familiar faces in the audience, people that I know have been actively engaged on copyright and IP for a long time, and I'm grateful that you're here and we can continue the discussion around TPP. I wanted to particularly acknowledge and give thanks to 2 people, though. First, Jim Balsillie, who in the last week or 2 has succeeded in doing something that many of us have not been able to do, which is to elevate these issues in a really meaningful way so that there's a genuine and really robust debate on some of these IP issues, which I think is fantastic. I'd also like to acknowledge and congratulate David Lametti on his election as a member of Parliament. There's something about when one of your own succeeds in that way that fills you with, I think, an enormous amount of pride and excitement. And David has been one of the truly exceptional scholars on intellectual property for many, many years. And so to see one of our own now elected as a member of Parliament is truly awesome. So congratulations, David. So you'll see the title of my talk is not exactly as advertised. I've instead called it Canada and the TPP, a digital policy failure. The reason for that is that as we were discussing what I would talk about at the time, the only TPP that we had available was a leaked version of the intellectual property chapter that had been made available through WikiLeaks a couple of days after the negotiations in Atlanta had concluded, alongside some government descriptions of the agreement that, if you take a look, I think aren't as robust as they might otherwise be. As many of you will know, over the last week or so, the full text has now been released, and so there's an opportunity, I think, to comment and engage not just, obviously, on a leaked text, but now on an official text that has been made available, as well as many of the other chapters that are there. Now, fear not, I only have 40 minutes, I'm told, and the TPP is a little over 6,000 pages. I am told there are more than 2 million words in the TPP. I haven't read them all. I'd be surprised if there were many people that had. So we're talking about an agreement that isn't your typical trade agreement. We're talking about a trade agreement that covers truly the waterfront of issues one that will have a profound impact on our economy, indeed on our society, in just about every meaningful and measurable way. I want to focus specifically, unsurprisingly, on some of the digital-related issues, though, what we in Canada have taken to call, or at least the last government had taken to call, Digital Canada 150. It's also something that you wouldn't necessarily expect to see within a trade agreement, but when you look at the TPP, you do find provisions that deal with IP around copyright and patents. You see privacy-related provisions in the agreement. There is stuff on telecom. There's a full e-commerce chapter that includes some of these provisions. In fact, and we'll have a chance to talk about it in a few moments, there is even internet governance-related provisions. I think a rather unprecedented step, both for our government and for many other governments, to move into the space of making commitments, regulating aspects of internet governance that previously, certainly in Canada, had remained outside the purview or the direct regulatory purview of the government itself. Now, this slogan, one that you find when you walk into Indigo about Canada, the world needs more Canada, I think applies in my critique to the TPP. I think the TPP needs or needed more Canada. The basic case that I'm going to try to make here is that much of the TPP does not reflect either our existing laws or minimally even an effort to try to take some of the kinds of policies that we have developed in Canada over the better part of a decade or more and seen ways to ensure that the world gets more of that. A beneficiary, I think, of benefit both to our businesses who increasingly need to ensure that they can comply with local regulations and knowing that those same rules and regulations would be applicable on a broad basis throughout the other TPP countries, but also because I think in many instances we got some of these policies right. Instead, what we get with the TPP, and you don't have to take my characterization for it, you can take the US characterization, this is a made in America